Good afternoon, well, it's now evening, ladies and gentlemen, and thank you, Radhika, for that wonderfully warm introduction. I had to change my jacket because it was jittering, and now I'm dressed like a lawyer on a panel with two of India's most eminent and leading lawyers. I'm not going to say lady lawyers because I just think that's wrong. They're lawyers first, and they happen to be women as well. And I think it is an honor and a privilege for me to chair this session, and I am very, very grateful to the both of you. The topic for today's session really is judicial autonomy, independence and institutions. The judiciary being the strongest link in the democratic chain. Both of you have held appointments with constitutional appointments and have had a plethora of judgments attributed to your names. My question to you, Indira, I've been forbidden from calling you ma'am, is when, in your opinion, has the judiciary in the last 75 years since independence, because the context here is the 75 years of independence and what we look forward to in the next 25 years and how we take this journey to 100 years. In your opinion, when has the judiciary been most autonomous, most independent?
Thank you. You're asking me to go back maybe 75 years.
Absolutely.
And
Why not?
Project myself into the future, another 25 years. So it's going to be, have to a recall from memory, if I may say so. Yeah. So I think the foundations of this country are very, very strong. And we are blessed with one of the best constitutions in the world. Why do I say it's one of the best constitutions in the world? Because it is, first of all, it's a post-Second World War constitution, and therefore heavily influenced by the Universal Declaration of Human Rights. So our country actually fast-forwarded many, many centuries into 1947. When we gave to ourselves this constitution, and we inherited a lot of the wisdom of the world, which is written into our constitution. Of course, we had wonderful people like Dr. Ambedkar to be in the drafting committee and give us the constitution that we have today. So this constitution sets up a governing ethos, which, for want of a better word, we have come to call as secular. And what does it mean? It means that each one in this country counts for one. Every single person is an autonomous human being, has to be treated with equality, has to be treated with respect, had to be treated with dignity. It doesn't matter what post you occupy, what position you occupy or you don't occupy. That is the guiding light of the Constitution. Now the question is, if this is the guiding light of the Constitution, who will deliver to us the promise of the Constitution? And the way it's set up is we have the executive, the legislative, the judiciary. Each of these branches is supposed to maintain a check over the other. And this is how we visualize the judiciary as an independent institution. Independent of what? Independent of the executive, independent of the legislature, and there for the citizen. Part 3 of the Constitution, the fundamental rights, are the most important provisions of the Constitution, and they're meant for people like you and me and everyone else. So that brings you to your question that first, you need to understand independence from what, and I've answered that question. Then comes your question, when was the judiciary independent? Now, in my opinion, it has been by and large independent, but there are two dramatic moments when I would have to admit that that independence was lost. And lost and regained Is it being lost again? That's a question that we need to debate today. So one was obviously during the emergency, when the Supreme Court rendered its ADM Jabalpur judgment, which was the lowest of the low water mark in this country. And it doesn't matter that 30, 40 years later you apologize for it. The fact is the judiciary did let the country down at the time when ADM Jabalpur was decided. I am sorry to have to say that we are passing through another such moment in history. But this time, more subtly, more surreptitiously, more without the declaration of an emergency. And I must tell you, it's much easier for a citizen, for a lawyer, to challenge authoritarian power if you have a document in writing which you can challenge. Today you have no such document in writing. But independence, in my opinion, to some extent is lost because the appointments which are being made to the Supreme Court are being made through the back door by the executive in this country. And although on paper we have a system which says that the collegium of judges alone shall decide who will become a judge and who will not become a judge, there is a consultation with the executive, and executive has often exercised sometimes a pocket veto, sometimes they just simply ignore the recommendation of the judiciary. And this is why I feel that we are today back again at a moment when we are in danger of losing the independence.
You mean like the ADM Jabalpur case?
True critical. Well, don't forget that the title of your event is the idea of India. So I've tried to present to you my idea of India.
Thank you very much for that. I'd like opening comments from you on that, Pinky. Not to say, I mean, obviously, it's not my place to ask you to respond, but should you choose to respond, please do. Yes, the ADM Jabalpur case is perhaps the biggest blot on the Indian judiciary. But having said that, there was also a Keshav Nand Bharti case which shows the independence of the judiciary at some, you know, in a stellar light, actually. My question to you is pretty much the same. In your opening remarks, would you like to highlight a time when the judiciary was very independent, when it was very, very autonomous? And I want to add something here, you know, as an observation. It is believed by a lot of people, both legal luminaries and observers, that the period from some time, you know, towards the end of Prime Minister Rajiv Gandhi's term, right up until 2014, was the heyday of the judiciary, and the judiciary was all powerful. And I don't want to go into the kind of conversation that sometimes comes up with regard to that, with overreach and perhaps what we studied in law school as judicial activism. But I want to limit this to the fact that, in your opinion, when do you think the judiciary in the last 75 years has been the most autonomous and the most independent? And do you believe a strong executive leads to a weak judiciary, and a weak executive leads to a strong judiciary?
That's quite a few questions all in one. But anyway, to come back to where we were, so two things I entirely agree with you and with Indira. ADM Jabalpur, the blot on the landscape. As far as the judiciary is concerned, let me just give you one specific answer to this. Today in India, if a common man has a grievance, will he go to the executive, will he go to the legislature, or will he go to the court? It is known and it is believed that a common man will approach the last court and the final court and the apex court because of his belief in justice. And that belief continues from 1947 till now. If you ask me what is the hallmark of constitutional reach, and I don't mean overreach, I mean reach, Keshav Nand Bharti possibly is across the landscape, which gave constitutional morality. In fact, it gave that soul into the body. So today also you find that that interpretation is being carried across. And I don't like the classification of 2014. It has overtones. However, I won't stress on it too much. But let me tell you that today, and for the last almost, and I'm taking it across board for some time, for the last about 20 years or so, the kind of rights that the judicial system has evolved for us, whether it is women's rights, whether it is human rights, whether it is children's rights, whether it is security of the country, which I think is one of the most integral parts of any of our rights that we are concerned with. I think we have evolved in every possible way. Just let's talk about Gul. We have, for example, the permanent commissions in the army for women. Look at the staggering nature of that judgment, and we can actually look across and say, so I believe in one thing. There are times when some of us lawyers say there's a little judicial overreach because a subject is being dealt with which possibly should not be dealt with. But then you cross the other side of the hurdle and say, well, things are not happening in the normal course of time. Things are not happening as required. You do require these rights to live in this world and for India to develop. So whether it's economic development, and incidentally there's a whole concept of economic legality, so to say. So you have this entire economic surface to look at to say how will India develop, and India has developed in leaps and bounds, thanks to the fact that we've been able to bolster our system with the constitutional strength and the soul and the independence. And lastly, if you talk about independence, I fear there is over-independence at times. Now, NJAC, the body that was set up by the government to look at the appointments and possibly the removals also of the judges as and when required. We only have impeachment, by the way, today. And impeachment has never been successful the world over. India not. Once it was tried, it fell to a lack of success. So ultimately, you had the NJAC itself, which was set up by the government, and by unanimity, by the way, across political parties. It was struck down by the Supreme Court. Now, what else do you expect to say in terms of independence? An independent judiciary who's dealt with every scam, they're about, offhand speaking, in the recent past, starting from, let us say, about 10 major scams, whether you take 2G, whether you take coal batters, so much so the Supreme Court has intervened at every stage to ensure that we have a clean landscape. Now, if that is not independent, what is? Only on the last front, you had a question regarding whether you have a strong executive, will you have a weak judiciary, and if you have a strong judiciary, you'll have a weak executive. I think we have made a difference. This country has made a difference. So you have a strong executive and you have a strong judiciary. And I think they run across pretty well in conjunction with each other, and there is nothing called I or you. It is I and you.
Thank you for that. I mean, it's very heartening and indeed very, very positive to have that outcome envisioned. I want to step back a little bit on, both of you are leading lawyers. You've had an immense contribution to the legal profession, but you also are women. I'm told things can be very, very challenging for women in court, and if a lawyer is doing well for herself, she's often referred to as pushy. What do you have to say about that? I mean, why don't you say something?
I think the answer is a little too obvious. Yes, a woman who speaks her mind is called, quote unquote, aggressive. Whereas a man who doesn't speak his mind is called, brilliant. And so that problem is there. I won't deny that problem. But there is, over and above that, over and above the fact that you're a woman, it also depends on the kind of cases that you take to court, which can bring hostility towards you. So in my case, I would say it's been a combination of being a woman and of being a person who's always taken very, very difficult issues to court, whether it was during COVID or whether it was the migrant workers or whether it's issues like hijab or whatever, So a hostility which is directed towards the person you're representing also gets directed towards you. It's what you call bias. So bias is of different kinds. It can be an ideological bias. It can be a sexism. It can be a misogyny. And there is always the ever-present threat. You told me some time ago that you address the people in the corporate sector and do trainings. But trainings about what? Trainings about the fact that all institutions must accept that sexual harassment is a no-no. So yes, there is a lot of sexual harassment in the legal profession as well. I have handled cases of public prosecutors who have raped interns and then asked for forgiveness I have handled cases of interns who have alleged that they were sexually harassed by judges. And most importantly, I handled the case of a district judge, a woman district judge, who complained that she was sexually harassed by a high court judge. Don't forget, the judiciary is one of the most hierarchical institutions this country has ever known. The legislature is more democratic, executive is more democratic than the judiciary ever has been. And I've handled that case where she had to resign because she couldn't handle the sexual harassment at the workplace. And ultimately, it was only a few months ago that after a 7-year battle, after going for an impeachment, we managed to get her back in the judiciary. So there is no end to the problems, but there is also no end to the success.
As we can see, absolutely. Pinky, do you have a take on that? Have you been called a pushy woman?
I don't know, people must be calling me pushy, but nobody calls me pushy on the face of it.
They better
so
not.
I don't know. But I can tell you one thing. Honestly speaking, most of my journey through law, I have not felt that there's some greater extra effort that I have to put in. There are a couple of them which I can't talk about, so I won't. But generally speaking, it has been a journey which has been a fairly reasonable one, considering the circumstances. So as a woman, I've enjoyed myself. As a lawyer, I've enjoyed myself in the beginning part, taken it very much in the stride. You do have to be pushy, you do have to be aggressive, you do have to be passionate, you do have to persevere, you do have to work hard, you do have to dedicate. So I know there are times that I've been called a few words, either by my colleagues also and even by my peers and possibly by the judges. But I do believe that doesn't make any difference to what I believe. However, I do want to instill into the other people who are practicing to say this: let us not be bogged down with cliches. Let us not be identified and characterized by characteristics. Let us not be said that, if you're aggressive, it's bad for a woman, or if you're aggressive, it's good for a man. There's no such attribute which can be different for a different gender. An attribute is either good or bad. Now, a lawyer per se is required to be aggressive. A lawyer is required to be pushy. A lawyer is required to make their way through. A lawyer is supposed to break barriers, and we've broken a lot. And Indira definitely has a distinction of having broken a lot of barriers, and she's right about some hostility. And it is a fact that when, for example, there are women arguing and men arguing, it would be said a woman is being extra belligerent, and that's not good. So, but as I said, personally, I have not heard any such views about myself. However, I'm sure they must have been made, and they would be there somewhere. But it should not affect you, and definitely the characterization, we have to change that. In fact, the Supreme Court has been changing this entire concept, and I think that is pervasive across the profession as much as other issues. So you say a woman, should not be demure. It is not necessary that a woman must be demure. You shouldn't be submissive. Well, do what you can do. We are half the world's space. Give us half the world's space, whatever we can do with it. We may be better, we may be worse. We may not be as good as the best lawyer in the country. We may be lesser than the next. We may be better than him. Whatever way it is, let us have our full due. We are citizens of this country, and we are citizens of the world. So give us a space, let us do what we can, and if we can excel, so be it, accord us for it.
Well said, well said. I want to go back to what is the subject of this conversation, which is judicial autonomy and judicial independence. I'd like a brief take from the both of you. In fact, I have a couple more questions, so I will request for a brief take. Speaking of autonomy and independence and pressure, lack of or not from the executive, how would you respond to the press conference by the judges? I mean, what do you make of it?
I was in Kashmir. I was there as a state guest, and I saw the notification on my phone. It says 5 judges of the Supreme Court are having a press conference, 5 sitting judges. I fainted. I didn't actually, but I almost did. I couldn't believe it. And when I even told my husband, I said, there's this press conference sitting judges are having. I hadn't seen the news. I just saw that much. But honestly, it was shocking. And I don't think it befits anybody. When you are in a position of power, when you are in a position that you're exercising over others, when you are in a position where we are talking about the independence and autonomy of an institution, you don't bring down an institution in that position of power. People in power have a responsibility to perform as per their positions. You don't overstep it. You are unhappy, you settle it inside. And frankly, I don't want to go into the merits of the issue. It doesn't make any difference, irrespective, right or wrong. You deal with it in-house. You do not bring it out in the open, because what you do, and when you talk about autonomy of institutions, one of the reasons India has been able to develop its institutions is because we have given them enough strength. There may be questions whether it's adequate, not adequate, less than adequate, whatever it may be. Be that as it may, you don't bring out an institution out. You don't bring the institution down. You do anything to make that work, and frankly, the issue itself also was highly questionable.
Your thoughts, Indira?
I have to disagree. It was very strange. We were all in the courtroom on that particular day. It was Justice Lohiya's case which was being heard by a bench presided over by Justice Arun Mishra. The court completed its work around 12 noon. And suddenly I heard these rumors in the corridor, the judges are having a press conference, the judges are having... Now, of course, to me also it was the first time ever that I heard that judges were having a press conference, but I got so excited that I decided to go for the press conference. And can you believe it? From all the lawyers in the country, I'm the solitary lawyer attending the press conference. Why did I attend it? Because it was a historic first. Why did I attend it? Because it was an open door conference. Anybody could walk in to the press conference. I have been stoutly criticized for having attended a press conference which is meant only for quote-unquote journalists. I had to disagree, and I had to say a press conference is open house for anybody, everybody. You can attend it. Now, coming to the main issue, what is very, very strange, and I was very happy because I said, this makes for transparency. Now, why did it happen? It happened because apparently the judges who had the conference had tried their best to do what Pinky suggested, namely resolve the problem in-house. And we were told that when there was no possibility of meeting the Chief Justice of India, then they decided to go for this press conference. Now, that was a great thing to happen, but in hindsight, what did we see? We saw the person who led the press conference, or rather was the senior most, or due to become the Chief Justice of India, get appointed, nominated to the Rajya Sabha. So that brings you back to your question, independence of the judiciary. Okay, where is this independence? Where are the barriers? Where do you draw the lines that this is your function as the judiciary and this is your function as the executive, this is your function as the legislature? So in hindsight, I would say that the press conference disappointed me, not because it was held, but because of events which transpired after the press conference and made me question, what was it all about? I still don't have an answer to that.
So I have two supplementary questions to that. The first one refers to the Honorable Justice Gogoi. And as lawyers, again, and who are women, the sexual harassment allegations against a sitting judge, and of course there is water over the bridge there, but sexual harassment allegations against a sitting judge being heard almost, in his own court. I mean, how would, if we were to redo that, and I'm speaking from the perspective of all those young women who are pursuing careers, who are in careers. One stellar one is sitting in front of us on table number 3, Sadamini. How would we do it differently? And my supplementary question really to that is, although not related, is what do you have to say about judges being made political appointees right after retirement? Now, there is a requirement of various commissions which require legal application and judicial application of mind, which require a dispensation of jurisprudence. So it's understandable why a retired judge would be made to head, say, XYZ commission, because there is judicial application of mind required, the NJAC, the NGT, and many other such commissions, the Armed Forces Tribunal for another. But When we see judges being appointed as governors, when we see judges being appointed as Rajya Sabha, rather nominated to Rajya Sabha, what do you make of that? So that's two questions. How would we do it differently? Of course, the matter is now done and dusted, but the sexual harassment allegations against Justice Gogoi, how would we handle them better?
I want to take this one. I'll tell you, I like the way you put the question. Because you said we're talking about what would we do for the purpose of a future benefit or to understand. So frankly, he should not have heard the matter. He should not have been there. If you have a sexual harassment case which is against you, right or wrong, that I'm not going into that, and you rightly didn't. But if you have such a case, it has to be heard by independent people, because there has to be an independent determination. So for the future, if such an occasion comes, yes, there should be such a determination. Second, your question about appointment of judges as political appointees.
Including but not limited to him.
Of course, in his case, the questions have come up far more, but frankly, history is replete with many instances. So you've had Justice Hidayatullah, you've had Justice Ranganath Mishra, you've had Justice Baharul Islam, you've had Justice Chagla, and some of the most eminent people who've not gone into politics and Rajya Sabha once, but sometime twice over. So frankly, that is not a question, and I'll link it to another issue. But I'll not, give me a minute.
I'm not saying only this government is doing it. It's been done before, but why? I mean, what do you make of it? What do you make of it from the point of view of autonomy and independence and the lens that we are viewing this through? I mean, what kind of how do we cast an eye on their independence given that they may take a political position? And this doesn't hold true for this government or every government has done it. But
you're right.
My question is about, and every government, I'd like to reiterate, so this is not about trying to bash a government that has been in power from 2014. I'd like to believe I'm far too balanced for that. But every government has done it. My question is, how does it augur for the independence of the judiciary when you're likely to become governor or a political appointee right after?
See, as far as the appointment as a governor is concerned, or even vice president, which has happened from a judge to a vice president, is concerned, you ultimately have positions, for example, in Rajya Sabha. Now, there are 12 nominated positions. They are given to people of eminent personalities. They're given to people like Sachin Tendulkar. They're given to Rekha. So they're given to totally independent people.
And Harbhajan Singh as well.
Singh, I mean, there are several other names. I can't obviously take all of them. So the question of appointing judges and Supreme Court judges or High Court judges as Rajya Sabha members is something which can flow automatically. You require people of eminence, whether as a governor, and incidentally, in today's world, the governor's role has become rather important. You are required to be independent and impartial. That is one of the constitutional obligations, by the way, which flows from the Constitution. So there is no harm in any manner of having, not only harm, I would say it's eminently desirable that you have people give their service. Supreme Court judges retire at 65. High Court judges retire at 62. So please tell me why we should not use the experience of such people into the political arena. In fact, being on that eminent position is supposed to be independent people. So it's not really a question only of political arena, but whether political, non-political, partisan, non-partisan, the contribution of people who are eminent in that domain as a generic question of appointment of judges is something I think which is very desirable, and it has proved to have fairly good results. Law itself has become an integral part of the parliament as much as of the country. So I think the interpretation of law, the putting into proposition as far as Rajya Sabha is concerned, and by the way, the last session, the last parliament session, I don't know how many bills we've had under consideration, and the number of legislations that have been passed in the recent past is amazing. And I'm not talking about 2014, I'm talking about even beyond that. So be that as it may, I like your question to be put in an overall perspective. I think highly desirable, and I do think that we in fact need to engage, and possibly this is something that I am saying, increase the ages of judges in any case. Maybe after that you can think of something else, but give them a term. Because today's longevity, today's experience and maturity, maybe 65 and 62 is something which is an age which needs to be considered. Bring it on par. Make both High Court and Supreme Court judges the same age. That will help a lot of issues to be removed out of the circuit. And to make that 68 or something to that effect as much as possible, considering what kind of age and experience we want to have in our favor.
Thank you. That was very incisive. Your thoughts on both the manner in which the sexual harassment case was handled?
I think Pinky's answered the first question. The first thing that the judge should have done is resign. At least step out of the judicial function and await the decision of any committee that may have been appointed. He didn't do that. The second thing is, the inquiry should have been conducted by an independent committee, not by a committee which consisted of those who were themselves in line for becoming Chief Justice and whom Justice Gogai himself recommended for being appointed. So to do it differently, yes, complete independence in the inquiry with the person concerned stepping aside during the pendency. I'm not saying resign. I'm saying just step aside while the inquiry is going on. Wait for the result. If you're absolved, you're back as a judge. And if you're not, consequences follow. So that's the first answer. Secondly, on the question of judges being on commissions. Now, I would prefer, your point was that you need the expertise of a judicial mind to handle a commission. I would prefer if sitting judges are appointed on commissions, right? There is not that lure of post-retirement benefit in that case. And you still have the benefit of a judicial mind. It happens during an impeachment. During an impeachment, a sitting judge of the Supreme Court is asked to sit on the inquiry committee. In that way, you're able to reconcile the need for a judicial mind with the independence of the person concerned. So that's the first answer. Yes, you can use your judges to be on commissions, but use them while they are still sitting judges. Don't dangle post-retirement benefits in front of their eyes. You've recently had the Chief Justice of the Delhi High Court. While he was still a judge of the High Court, he was promised a job in a tribunal. Now, what then are you going to make of this? Are you not going to think that during his tenure as a judge, he's going to give judgments which will enable him to get post-retirement jobs? So I think this post-retirement appointment of judges is a very serious issue. If at all you want them, have a cooling off period of a couple of years, 3 years, whatever you want to have. It applies to the bureaucracy as well. So I don't understand why it should not apply to the judiciary. And it's a serious matter. It does compromise the independence of the judiciary. Perhaps the solution, if I heard Pinky right, was to say, yes, our judges retire at 65 years of age. It is, in today's context, rather young, when they're still full of energy, when they're still full of imagination and creativity. Perhaps we need to raise the age of retirement to at least 70, I would say, if not more. But that's a debatable issue. So that's mine.
Thank you for that. Unfortunately, that's all we have time for. I would have liked to continue this much, much longer, but I'm grateful for a fantastic audience and, of course, grateful to both Pinky
I have a last statement, Gul, before you even wind up. Incidentally, Gul is also a lawyer. So let's applaud Gul on this moderation. She's recently acquired this degree and joined the ranks. I think she's trying to compete with every part of the world in every versatile direction that she can.
Thank you for your kind words. Thank you so much, Indira. Thank you so much, Pinky. Thank you, ladies and gentlemen.
Please stay on stage. All right, thank you very much, Gul. I think we all agree being a lawyer suits you. Yes? All right, thank you very much for your time, Ms. Jaising and Ms. Anand. I think I speak for everyone when I say that, you are inspiration for not one but many generations of women who know because of you that it's important to make it on your own terms and be trailblazers just as you both have been. I'd like to invite on stage Pushant Chakrabarti, Chief Financial Officer, ABP Network, and also Kaushik Roy from Reliance Industries to present a memento of our thanks to both Ms. Jaising and Ms. Anand. Please show your appreciation for our fantastic speakers who really shared their incisive thoughts. They've articulated them so well for us, and we're going away richer after this session. Thank you very much, Mr. Chakrabarti and Mr. Roy. Thank you very much. Ladies and gentlemen, please do stay on with us. Something very exciting lined up for you. Please do stay with us. And in just a moment, you'll know exactly why. A little bit of patience from you. If I can just have all of you back in your seats for a moment. We're actually going forward with another session at the moment, and this is one that you do not want to miss. There's going to be a lot of humming, a lot of foot tapping, and a better understanding of how the music world in our country actually operates. It's a very special session. Music, as we all know, is an integral part of our country, our culture. In the northeastern states, it's part of each and every household. And thanks to social media, India is actually now discovering the massive talent that resides in the 7 sister states, as they are called. We are now joined by someone who has not only made a huge mark in Assam, but has brought that energy, that vibe to Indian film music. Please welcome Angaranga Mahanta. And if you're getting confused who I'm talking about, put your hands together for Papon, ladies and gentlemen. And to facilitate this conversation, it's my pleasure to hand over the chair to Romana Isar Khan. Hello.
I think so we need to adjust them. आ गए? शानदार. और नीचे आ जाओ ना फिर मैं आपकी वजह से. हाँ, शानदार तरीके से लगे ना आप. तो एक बार जरा शुरू कर सकते हैं हम?